SJC-12352, Terry Bridgwood v. A.J. Wood Construction, Inc., and another.
Mr. Toulan, we're all set for you. Before you start, before the clock starts, at least on my iPad, there's no page 6 of the judge's decision. Is that an error in terms of the copying, or is that not part of the record for some reason?
That should have been part of the record.
Okay.
Does appear in another place in the appendix.
Okay,
There's
so
another version of it.
another version of it, okay.
Yes, I believe that's correct.
All right, we'll track it down.
And
All right,
I apologize for that oversight.
your fault. You may proceed.
My name is Roy Toulon. I am the attorney for Plaintiff Terry Bridgwood in this matter. This is a matter which involves the application and breadth and depth of Chapter 42A of the Commonwealth of Massachusetts, which is I dare say, a multi-purpose statute. It is deemed to be a Consumer Protection Act on the one hand, and on the other hand, it provides a needed provision for additional housing, low-income housing in the Commonwealth of Massachusetts. Just briefly, the statute operates by collecting people who are contractors, who can get registered under the 142A paradigm. The only contractors that don't have to be registered are those which have licenses, such as plumbers, et cetera. The registration process is such that there is a pool of contractors that is available to assist in the rehabilitation of low-income housing, generally in inner cities. The plaintiff in this case, Terry Bridgwood, is a private citizen and is the type of person that 142A was designed to attract. She purchased for lack of a better term, a rundown a three-floor residence in Newburyport. Part of the requirements of 142A, which is a rather stringent and I think rightly so statute, is that the owner has to live in the property which is going to be renovated after it's finished, and that the other at least one other apartment must be rented out to a person who qualifies for the 142A program in terms of income level. This case arises out of a post-purchase of the property and the rehabilitation of that property. And I'd like to start out with the timeline of this because we are dealing with a statute of limitations and some issues about statute of repose, so I think a timeline is important.
And let me ask you this before you go there.
Yes.
Let's assume you're right. Let's assume you win and the statute of repose does not apply to 93A claims. Is that effectively going to undo the statute of repose with regard to common law torts under Section 2B?
No, because this is not a common law tort under that section.
But I mean, are we going to be, or is it going to mean that every time there is a violation of a building code rule, we are going to essentially undo the
No,
statute?
that's not true because of the structure of, again, the structure of 142A is very, very precise. And if I may, perhaps we can just take a look at that because that is something which runs through, is a line which runs throughout all of the arguments in this case. 142A, Section 17 is entitled Contractors or Subcontractors Prohibited Acts or Violations. And in that sense, 142A is itself a consumer protection statute because it governs what contractors can do when they are operating under the purview of 142A. Section 17 of 142A, which is a section entitled Following Acts Are Prohibited by Contractors and Subcontractors, has in subsection 10 of that statute, that that the following acts are prohibited by contractors or subcontractors. And subsection 10 is violation of the building laws of the Commonwealth or any political subdivision thereof. So a violation of any of the building laws of the Commonwealth is a violation of Chapter 142A.
Yeah, but don't we have a number of cases like this? I mean, the appeals court has decided a number of cases where essentially we look to the gist of the action, and isn't this the gist of this action is negligent construction, isn't it?
No, because the gist of the action is not the appropriate standard to apply here. This is the interaction between two statutes, 142A and 93A, and how they play with each other, play against each other, and some hopefully in a beneficial conspiracy for the purposes of the Housing Act that we're looking at. 142A provides that violations of any of the provisions of this chapter shall constitute an unfair and deceptive act under the provisions of Chapter 93A.
But we've said that in 93A cases. We've looked even in 93A cases to determine what the gist of it is. We being, at least at that time, the appeals court. Justice Duffley wrote one of those decisions right when she was on the appeals court.
Well, I think the unique thing about this thing is it goes the other way. Generally, those cases I'm familiar with have taken 93A and how does this apply to other sort of, quote, normal cases? This is just the opposite. This is how does this 142A play with or are connected with 93A. So we're not starting with 93A. We're starting with 142A. And what 142A has is a list of 16 items that have to be complied with by the contractor, such as operating without a certificate. That's not allowed. Failing to provide a credit to the owner, et cetera, et cetera.
But that's not what we're dealing with here. Here we're dealing with negligent electrical contracting work, right?
I'm not sure I'm going to call it negligence. I'm going to call it an unfair and deceptive trade practice.
Well,
I don't think it's negligence.
That's a label. What is the underlying claim about?
The underlying claim it deals with an electrical contractor who is supposed to completely redo the electrical system of this rather old house, apartment house. The original wiring was knob and tube, and I think people are familiar with the knob and tube. It was sort of interesting. This case was decided in the lower court by Judge Lang, who informed us from the bench that before he was an attorney, he was an electrical contractor in the Commonwealth of Massachusetts. So he looked at some of the pictures that we had, and he said, "This is not code." But for other reasons, voted against us.
Judicial notice of
sorry?
electricity, judicial notice?
Yes, that's true. So.
And the motion to dismiss was allowed anyway.
So what we have is a very, very comprehensive consumer protection statute in 142A. And 142A says that if there's a violation of any of the 16 provisions of 142A, the one that we're dealing with being that there has to be a failure to comply with all of the building codes, building law rather, in the Commonwealth of Massachusetts. So if there's a violation of the building law in the common law of Massachusetts, 142A says that any violation of the provisions of this chapter shall, and I think for me that's an important word, going back to law school, the distinction between may and shall. This is shall, it's mandatory. Shall constitute, and it doesn't say a violation of 93A. It doesn't say that. That would leave the scope of what this court had to do to be extremely wide and somewhat uncertain. But I think the legislature was very smart in what they said here, because what they said here was violations of any of the provisions of this chapter shall constitute an unfair and deceptive trade practice under the provisions of 93A. So there is this solid intrinsic connection between this residential creation of good housing that we call 142A and 93A. 142A just grabs 93A and pulls it right into the statute.
So which came first in terms of time? The addition of the statute of repose to Section 2B, the enactment of Section 5A, providing for a 4-year statute of limitations for 93A, or the passage of 142A, Section 17?
I believe 142A is at the end of that.
So that's last. So the legislature did that after the other two. And in terms of the statute of repose versus Section 5A?
That is, I'm not sure when that was, but I think that was also before.
Before what?
Before
Section 17?
Before 142A.
Okay, but how about between 2B and 5A? Were they done at the same time, or were they done?
That I don't know. That I don't know. Okay, but the position that we're taking here is that the statute of repose does not apply.
Right, I understand that. But of course, one question which we're going to ask your brother is, the legislature addressed 93A in a separate statute and did not include a statute of repose with regard to that statute.
That's correct. 93A has its own statute of limitations that does not have a statute of repose as a part of it. And even if it did, I was taught never to do this in law school, but even if it did, it still is okay. And because the facts of this case are as follows, is that under 260 Section 12, the statute of limitations is told if the wrongdoer either concealed the existence of the cause of action through some affirmative act done with intent to deceive. But we already have deception going on here, don't we? Because that's part of 93A. But there's another deception that's going on here, which is significant. What we're complaining about is the electrical contractor. Now, under 142A, the general contractor is also brought in because the general contractor has ultimate responsibility for all of the work done on the job. So the general contractor is also named as a party defendant. But the real character here, the real bad doer, the real wrongdoer here is the electrical contractor. Because the electrical contractor was faced with a house that was very, very old, and it had what is called knob and tube wiring. And the knob and tube wiring generally is some ceramic knob that has a relatively flimsy wire wrapped around it going to the next, and then maybe shooting off to lights and things like that. It's been illegal in the Commonwealth of Massachusetts for many, many years. So that all of the electrical service in this house had to be replaced with current cabling, current junction boxes. And I think the current cabling, I forget the name of it, but it's a plastic tubing. It's not the metal wound one. It's a plastic one.
But now you're confusing me, because are you claiming that even if there's a statute of repose, you can still win because there was concealment? I'm not aware of that being an exception to the statute of repose.
I am saying that one of the things that tolls the statute is lack of knowledge.
Oh, sorry, tolls the statute of limitations?
Yes.
Are you saying it tolls the statute of repose?
No, it tolls if the.
Oh, okay, so you're saying if you have a 4-year statute, you would get tolling because it was concealed?
Yes.
Okay, I'm sorry. I thought you were.
Because it was hidden. And the hiding has to be done on purpose. And what happened here is instructive, I think, of this entire case in terms of the severity of what was of the wrongdoing, unfair and deceptive trade practice. To my mind, in terms of 93A, the unfair and deceptive trade practice was as follows. My client lived in the top unit. Stairs came up, wall, general stuff. living room, etc. Right inside the door was a medallion. We don't have one here. They're fancy. That has a lighting fixture in the middle of it. And sometimes like with plaster with leaves and and flowers and stuff like that. If you took, after the job was done, if you took down the lighting fixture, you would see the contemporary wiring, the contemporary cable, the plastic formed cable. If you went 10 to 15 feet away from that to the source of the electrical power, the modern cable stops, and it's tied into the knob and tube cabling or the electrical connection that was there for eons, that was supposed to be replaced.
But
Now-
isn't that a negligence claim?
I'm sorry?
Isn't that a negligence claim? And I mean, there are at least a couple of cases that say that if it's a negligent construction one, even if it's a 93A action, then it's barred by the statute of repose. Don't we have to reverse both Judge McHugh's decision in Kelly and also Judge Duffley's decision in Fine to get to where you want to go?
My presentation to the court is based on the overriding presence of the building laws and the consumer, as they play with, as they tie into the consumer protection laws of the Commonwealth of Massachusetts.
Right, but just so, both Judge Duffley's decision and Judge McHugh's decision were 93A claims, and we applied the statute of repose to those claims.
If in fact the gist of
The
those
only
claims-
difference between your case and this case, those two cases, is that you've got this 142 element to it.
That's correct, which is an independent statute, which says a violation of what you're supposed to do in terms of the building is an automatic violation of 142A, which is not, it doesn't say that it's an automatic violation of 93. It's even stronger. It says it's an unfair and deceptive practice under 93A.
All right, thank you.
Okay, thank you.
This is for you.
Oh, thank you.
Good morning, Your Honors. May it please the Court. Lily Geller for the defendant, A.J. Wood, the appellee. As much as the plaintiff would like to make this case not about a tort action, it is a tort action in the context of home improvement, constructions and renovations. And to pretend or ignore that the statute of repose does not exist is basically to have this case be about mere labels, to
Well,
be about recasting.
what is the statute of limitations here?
Your Honor, this is not respectfully a case about the statute
I
of
understand, but which statute of limitations would apply?
The statute of repose, the statute of
I'm
limitations.
sorry, try
that
my
would apply.
question. Which statute of limitations would apply?
Chapter 262B, the 3-year
You're
statute.
saying that the 3-year statute as opposed to Section 5A?
Yes,
Which
Your Honor.
expressly says that for 93A, it's a 4-year statute?
Yes, Your Honor, and respectfully, the argument that we would make, Your Honor, is that this is a claim that the plaintiff has brought in the, as he has said, the interplay between 142A and Chapter 93A. 142A, just as 176D, does not provide for a private cause of action. So therefore, you must look to what the enumerated violations are and how it connects with Chapter 93A. In this particular context, the claim is that my client, as the general contractor, violated the building laws of Massachusetts under 142A, Section 1710. No different than the obligation that my client would have had, irrespective of the existence of that statute. We're all obligated to comply with the law, whether enumerated in 142A, 1710 or not.
But certainly if you had filed a common law tort claim of negligence, you'd be under 2B. But I don't understand how you can say that when the legislature says that 93A claims for damages shall be commenced only within 4 years next, that you're going to say, oh, well, it's a claim under 93A, but we're going to reconfigure it and say it's sort of like a common law tort, or maybe it's sort of like a common law contract claim, and we're going to say that we're going to blow off the legislature's declaration that there's a 4-year statute of limitations for 93A claims, and we're going to apply the common law claims. How can you do that?
Your Honor, the court has already done that in both Claremont and Klein when analyzing 93A.
No, it didn't. Claremont specifically said that not every violation of a building code is a 93A. It did not address the statute of repose, nor did it address the statute of limitations.
It set forth an analysis, and that's what I would respectfully argue is at issue here. The analysis is looking at the gist of the claim. 93A is neither wholly tortious or contractual, and in this context, Your Honor, the claim is tortious in nature. The plaintiff has alleged that my client failed to comply with the building laws, which is no different than the court has already held. Negligent workmanship does not toll. There is no tolling of the statute of repose. That's a misnomer insofar as that applies to statute of limitations and not statute of repose. The court has been very clear that even in the case of minors, in the case of relation back, that the statute of repose is not revived. It's a statute where the intent was to place an outer limit on the obligations of contractors to let them rest. To have otherwise would basically to have general contractors, and in this case, home improvement contractors, be liable forever, plus 4 years, Your Honor. In this case, the analysis, as the trial court did, was to look at the underlying conduct. To have it be that a claim is neither wholly tortious nor wholly contractual doesn't mean that it's neither. And in this particular case, it is tortious in nature, just as the court has analyzed violations of building codes in Claremont, and just as it analyzed claims of implied breach of warranty of merchantability in Klein. And in both those cases where 93A was pled, Your Honor, the court has determined that the statute of repose still applies, and that places a clear language that in no event shall claims be brought beyond that period of time when there has been substantial completion in the home improvement or it's been delivered to the owner. The intent of 2B, Your Honor, as you all know.
And I'm aware of the intent of 2B. The question is, what is the intent of 5A?
The intent of 5A is to place a 4-year statute of limitations on those actions enumerated therein and in contract claims. 93A is...
I'm sorry. Enumerated therein, 5A applies to 93A claims.
It does, Your Honor.
And so your view is it applies to 93A claims that are not that could not be viewed as common law tort or common law contract claims, that we have to carve out a subset of 93A claims which do not fit into either category? That's not what the statute says.
Your Honor, the plaintiff is respectfully asking that there be a carve-out for 142A, which is not enumerated therein. There is no exemption. I mean, he may be arguing that, but I'm saying, well, I'm looking at that the legislature said 93A, that the appropriate statute to use is 5A, and for whatever reason, the statute did not add on a statute of repose to it, even though the legislature was aware under 142A, Section 17, that construction defects could be a 93A violation. So the question is, what did the legislature intend to do here? And, Your Honor, I would say that when the legislature enacted statute of repose in 1968, it intended to place an outer limit on the liability of contractors, balancing the equities between the public's right to a remedy and placing that outer limit on contractors. 23 years later, when the legislature enacted 142A, it did not in any of its language exempt the protections afforded to that group under Chapter 260, Section 2B. There has been 27 years since the enactment of 142A in 1991, and there has been ample precedent and policy and opportunity for the legislature to revisit that. And to this date, Your Honor, there is no exemption and no authority cited by the plaintiff that would have us unwind the statute of repose and essentially eviscerate it for a class of contractors, home improvement, the result of which would come back respectfully to bite the very consumer that is intended to be protected, in that there would never be an end to a contractor's exposure. There would never be an insurer willing to underwrite that risk forever.
Can I ask, I just want to make sure I understand in response to the Chief's question. So he asked you about the statute of limitation. You disagree with him on the statute of limitations. Can he be right on the statute of limitations and still have the statute of repose from 262B apply?
Yes, Your Honor.
I'm trying to understand why that fight matters.
Go
Go
The
ahead.
fight matters, Your Honor, insofar as that 93A is a 4-year discovery statute, whereas the statute of repose sets an absolute limit. All the statutes can
But my
live-
question's narrow. If the chief is right and you're wrong, that the 4-year statute of limitations applies from 93A, does that mean that the statute of repose in 2B doesn't apply? Or could you have a 4-year statute of limitations and have the statute of repose apply?
Yes, and I believe that's what the trial court's decision sets forth, Your Honor, that the
So why are you
interplay...
arguing that other point? I'm not sure what the point of it is.
If I misspoke, Your Honor, it's really the argument that I'm making is that they can all live harmoniously, and there has been no language to the contrary, either in the legislature or in the case law, that would have them sort of conflict. And the intent in reading legislation and statutes is that there's a harmonious interpretation, which is permitted in this case. All three can live together. If you have a violation of 142A, the building laws, which may make it easier for a plaintiff to prove unfair and deceptive act or practices under 93A. That does not eliminate their opportunity to do that, so long as with any other statute that there's a compliance with that statute of limitations, and the outer limit being the statute of repose. Thank you, Your Honors.
Mr. Darling?
Good morning, Your Honor. If it may please the court, I represent Anthony Caggiano, who is an electrician in Massachusetts. In the year 2000, he performed some electrical service at Mrs. Bridgewood's home and made a small fee for that. This was not a job that involved the whole rewiring of an existing building. It was a limited job. Representations to the contrary, we never got to.
Well, if he was still negligent, he would still be responsible if you don't have the statute of repose.
Exactly. That's where I'm going with this. There were some representations made in plaintiff's argument about a big job being done here. We never got there in the underlying case. This was dismissed on a motion under 12C. We never did any discovery, and the materials that were appended to the motions in the trial court were not considered by the justice who made the dismissal decision there. Now, I don't have an awful lot new to say. Attorney Geller covered most of the ground the defense presents to this court, but there were questions about the statutory history, and I did focus on that in my brief, so I'll try to address those that Judge Gantz raised. In 1968, the legislature passed the statute of repose, and that was in response to a change in the common law which had done away with privity requirements and actions against contractors and architects. The legislature saw that as opening those contractors and architects to unlimited liabilities that could track them for the rest of their lives, right through their retirements. So the remedy chosen by the legislature was to limit those causes of action to 6 years, and the statute of repose was passed. In 1991, the legislature, addressing a different public need, passed the Home Improvement Contractors Act, and in that addressed concerns that the public had about contractors who didn't do good work. And they, in Section 17, enumerated the ways in which a contractor under that statute could violate the law and therefore be exposed to liabilities. There is no statute of limitations in the Home Improvement Contractors Act. The legislature left in place the tort statute of limitations, the contract statute of limitations, and the Chapter 93A statute of limitations,
Okay,
Section
what
5.
What year was that enacted?
Of the 93A?
Yeah, Section 5A.
Honestly, Judge, I did not research it before coming to court today.
Before 68?
I'm aware that the Chapter 93A was passed in the 1960s and amended multiple times. I believe the statute of limitations has been with it through all those years.
So that was there when the statute of repose was enacted in 68,
I believe so.
and it was limited to Section 2B.
I'm not certain I understand that question, Your Honor.
The question is that it did not add to Section 5A a statute of repose.
That's right. When the 93A has never had a statute of repose feature.
But why should it now?
Because a Chapter 93A cause of action based in underlying circumstances which are tortious falls within those cases which the legislature intended to end after 6 years.
So let me ask you the question I asked your sister. What's the statute of limitations here?
I believe it's 4 years under Section
So
5B.
why does 5A apply to the statute of limitations and 2B applies to the statute of repose?
Because the statute of limitations under for a 93A cause of action is a separate statute of limitations. Section 2B, and we have separate statutes of limitations for tort claims and for contract actions and for 93A actions. 2B applies to all of them. The statute of repose is
But
not a statute of limitations.
You just told me that you just told me that 2B would not apply if it was a 93A claim that arose out of a construction.
I did not intend that to be
So
the answer I gave.
your view is that in this case, even with the 93A claim, the 93A claim would be governed by Section 2B.
I do. That is the law.
That's the law? Well, we'll find out, I guess.
Well, that's the law as it's been applied by the appeals court in other cases, Judge, and that is, I guess,
So you interpret Section 5A to say 93A claims that are not based in tort or contract have a 4-year, but if they are based on tortious or contractual violations, then they will, then the statute of limitations for tort and contracts will apply? Is that what you're saying?
What I'm saying, Your Honor, is that the statute of limitations under a 93A cause of action is 4 years under Section 5.
Even in this case?
Yes, even in this case. It's always 4 years. But a statute of repose, which is not a statute of limitations under 262B, prohibits a cause of action after 6 years against the protected class of people under the statute. It's a statute of limitations and a statute of repose are different animals.
I'm aware of that, but I'm also aware that is it not reasonable for the legislature to say we're not going to give you a statute of repose for 93A claims, but we're going to give it to you for common law torts?
If the legislature intended to exempt the 93A cause of action under the Home Improvement Act, when they passed it in 1991, they could have easily done so by adding a provision to the statute. They didn't.
Why would
Why
they feel they needed to if all they said is that that violation is under 93A? Aren't you assuming, you're assuming that they accepted your understanding? They could say,
I'm trying.
They could say Section 17 is an unfair and deceptive practice. You can therefore bring a 93A claim under Section 17, and there is no statute of repose under Section 5A, and therefore we're going to leave it that way.
Applying rules of statutory construction, Your Honor, the court generally does not assume that the legislature was unaware of a prior statute, to be in this case, when they pass new legislation regulating the same area, contractors in this circumstance.
But you're assuming that the law in 1991 was that there was a statute of repose under Section 5A with regard to torts arising out of deficiency or neglect in construction.
Well, there certainly was a statute of repose that protected contractors under Section 2B.
Right.
And my submission is that that statute of repose applies to contractors whether they're sued in tort or in 93A if the underlying cause of action is tortious at its gist.
Why can't the statutory construction go the other way? So 142A passes. There's some 16 provisions that, including violations of the building code, that basically constitute a violation of 93A. Why couldn't you do the statutory construction and legislative history as saying there was no need to include a statute of repose because we're tying into 93A?
Because the actors here, the contractors, electricians in my client's case, are protected by the statute of repose. And if it was not to apply in these circumstances, the problem that was addressed in 1968 of the lifelong exposure of contractors to potential liabilities would be undone with the passage of the Home Improvement Act. The law, when you're construing statutes, looks to determine whether you can read these two statutes consistent with each other, give them the words of the statutes their ordinary meaning, and render a sensible result. And as Judge Lang did in the trial court, you can apply both the statutes without finding a conflict between them, protect the homeowners under the Home Improvement Act for at least 6 years, and protect contractors from claims that rise after the 6-year period, without finding some conflict that needs a remedy in this court. So,
Can I ask you the Chief's original question to your brother, which is, if we remove this statute of limitations, statute of repose, will essentially the 93A claims basically consume all of basically wipe out the statute of repose?
I believe so, Judge.
'Cause I assume most of these negligence cases, we're now going to have building code violations. Building code violation almost inevitably leads to a 93A action.
It could certainly be pled in almost every complaint that a contractor who did a job violated code if he didn't, do some element of the job properly. That would open those claims to litigation many, many years after the work was actually done, and I think undo the protections of 2B. So, unless there are further questions.
All right, thank you.
Thank you.